I'll introduce myself. My name is Ali Talai. I'm a trust and estate planning attorney, and today I'm going to talk to you about how to eliminate estate taxes, protect your estate against future lawsuits. Hopefully that's a good topic for everybody here. Let me tell you a little bit about myself. I'm a trust and estate planning attorney, and we have our office here in Los Angeles in a city called Woodland Hills. I know most people are familiar with Woodland Hills is. We are only a trust and estate planning law firm. I have an advanced degree in tax law. I started doing estate planning and then started to figure out it would be a good idea to have a little bit more knowledge about tax law as it relates to estate planning. That becomes a pretty important aspect of the law as it relates to these sort of plannings that we do. So we do a lot of advanced estate tax planning, we do a lot of asset protection planning, we do some business planning, and we do some probates and trust administrations as well. I host a weekly radio show on the Persian radio, so if your Farsi is a little rusty, do not worry, I will speak English for today most of the time. And but yeah, if you ever wanted to listen to more estate planning information, I do a lot of online, a lot of social media. If you follow some of our accounts, we post almost daily, 5 days a week. So hopefully you could provide some more information as far as estate planning. I have written a book. This was last year. I'll talk about it a little bit more towards the end. And we do have some here. So if you decide to purchase one, you're more than welcome. All right. So today, what I'm going to hopefully talk about, and I only have 20 minutes. So hopefully we're going to get through as much as we can, but my goal today is to talk to you about how we could avoid the lengthy and costly process of probate using a trust. I want to talk to you about why a revocable living trust cannot avoid estate taxes and cannot provide any asset protection. And I also want to mention that a land trust is a revocable trust, and we'll talk about that a little bit more. I want to talk to you about proper asset protection planning, and then the last part is how do we do estate planning, and I'll show you some of the tools that are used so we can disinherit the IRS. Nobody wants to give IRS anything. That's my goal today, and I hope that after I'm done with this 20 minutes that there's at least one thing that I could maybe go over that you would think this is new, I didn't know that before. That's my goal today. All right, so let's talk about this probate process. I know a lot of people know what probate is, but just to kind of explain it quickly, it's a court process that if somebody owns a property and it's under their name solely, and now this person passes away, the probate process allows and provides a way so that the asset could pass along to whoever it is, if it's a child, a spouse, but that's what the probate process does. It takes a long time here in California. LA County, probably the worst out of all the other counties, but it's a year and a half is average in our office for probate process from start to finish. It's costly. Anybody could go to court and find out what assets you have and who's getting it. So again, not ideal. And so what we can do is we can set up a trust, and that trust can avoid the process of probate. And what I want to explain to you is that how does a trust now avoids probate? Who has a revocable living trust here? All right, so excellent. So we have some people that have the revocable living trust. So in order to really do this thing, we got to create a trust first. And then in a trust, there's 3 main roles within the trust. A lot of the trusts that we do have 4, but the main 3 is the person that creates the trust. They call that person the grantor. And then sometimes in some of the documents, you'll see this person called the settlor, the trust maker, the trustor, just to confuse us more. Not that these things are not confusing enough. So you have 4 different names that relates to the person that creates the trust. That's the person that creates it. Then you have a trustee, that's the manager, and then you have a beneficiary. And one thing with beneficiary is that you really have 2 types of beneficiary. You have a present beneficiary, and then you have a future beneficiary. So the ones that raised their hand, they said they have a revocable living trust. A lot of times when I ask the clients who's the beneficiary, they say my kids, and that's not true. Your kids are a future beneficiary. The current beneficiary of the trust is you, the person that has created the trust. So those are the main three roles within a trust. If somebody asks you what role you want to be, you would probably want to be a beneficiary. That's probably the best one. You get all the assets, you get all the benefits, and you don't have to deal with the trust administration and all the other hassles that could come up with the trust. And then the other part is, so we create the trust, then we got to fund it. We got to transfer our assets in there. So now if I have a home, I have to make sure I change the title of the house and transfer it into the trust. If it's just under my name, or if it's just under the trust name, if it's just under my name, it's not going to do anything. I forgot to clock my time. So now we got a trust, we transfer our assets in there. At the time the person that creates the trust, at the time this person passes away, the trust itself does not pass away, it does not expire, it does not terminate, the trust stays alive. That's one of the main character of the trust that allows us to avoid probate. Let me give you an example. So let's say you and I negotiate and you agree that you're going to sell one of your properties to me. I know a lot of apartment owner associations don't like to sell their properties, but let's say I convinced you, I offered you a good price, and you're going to sell your property to me. What we're going to need is we're going to need a deed. We're going to need a deed that would transfer the property. And in a deed, the person that is transferring the property, so if you're the seller and I'm the buyer, you sign the deed as the grantor, transferring the property to me as the buyer. In exchange, I will give you cash. I'm purchasing the property, I don't have to sign anything. Let's say I got you on a really good day and you say, you know what, I'm just going to gift it to you. You don't have to give me anything. It doesn't matter. We still need a deed, and the deed, you as the grantor will have to sign it. Now let's say in this example, the person that owns the property passes away and the property is supposed to go to the kids. We still need a deed, and then somebody's got to sign it. Obviously the person that passed away cannot sign. So then when we go to probate court, one of the first thing the probate court does, they appoint someone and give that person the power to sign on behalf of the estate. So now a deed is prepared, the administrator signs the deed, and the property gets transferred to me. When we are in a trust setting, the property is in the trust. I said when I pass away, my trust doesn't pass away, so it's alive. And then the trust already has someone appointed within it that would have the power to sign on behalf of the trust. So there's no need for us to go to court to get a court order to transfer the trust. And that's how we're able to transfer and avoid probate, by using a trust. And so if you have not done your estate planning, one of the first trusts that you set up is a revocable living trust. And it's intended to avoid probate. It's intended to avoid probate at the time the person loses capacity, and obviously if the person passes away. All right, so sometimes one of the goals to create these sort of plans is to avoid, beside avoiding probate, is to avoid any lawsuits, or at least protect our asset against lawsuits and estate taxes. And a lot of the questions I get is that people assume that just because they have a trust, just because they have a revocable living trust, that at the time they pass away there would be no estate taxes, or if there is a lawsuit filed against them, there would be that the creditor couldn't attach and take the property that is inside of the trust. But that is not true. It really depends on the actual structure that we have in place. So let's go through an example. I get in some sort of a trouble, there's a lawsuit filed against me, let's say for some reason they get to win, they get a judgment for $1 million, right? It's obvious that any property that I have under my personal name, they can attach. So if I have a property that is under my name, they can attach it pretty easy. If I have bank account under my name, they can attach it pretty easily. But then now I create a trust and I have transferred my property in there. For the purpose of probate, I just mentioned to you that if you have a property in probate, in the eyes of the probate court, you don't own the asset. And so if I pass away, the probate court says these are not probatable assets, so there's no need to go to probate. However, if we're talking about a lawsuit, the court doesn't just stop if I say I have my property within a trust. They want to see the trust. They want to see what kind of powers I have kept within the trust. So if I have a trust that is a revocable living trust, right? And it's a revocable living trust. What does a revocable living trust allows me to do? As its names suggest, I can revoke it, I can change the beneficiaries, I am the beneficiary, I can practically do anything I want to do. So in a case like that, the court says, the fact that you have a revocable living trust, that is not going to be enough to provide any asset protection. A land trust, those are just another version of a revocable living trust. So a land trust by itself does not provide any asset protection. We use land trusts in some of the plannings that we do as a combination with some of the other tools that are available. But I don't want you to get the sense that just having a land trust will be sufficient to provide asset protection. That is absolutely incorrect. So if we're doing asset protection planning, step one, the first characteristic of this trust, it has to be a trust that is irrevocable. And all that means is that this is a kind of a trust that I will not have the power to revoke. So now if somebody sues me, they cannot force me to revoke the trust and take the property out because I don't even have that power. If somebody sues me, can they take your property? No, I have no ownership. I cannot revoke your trust. I don't own the property. So one of the first steps in a kind of a trust that we'll use for asset protection, it has to be an irrevocable trust. So a revocable trust cannot do asset protection for the creator of it. All these revocable trusts, unfortunately, at some point they'll become irrevocable, because if I create a trust for myself, I am the only person that can revoke it. And since one day I will pass away, my revocable trust automatically becomes irrevocable trust. I can do asset protection, I could do estate tax planning for my beneficiaries. A lot of times we create a trust for our beneficiary within these trusts. And so we could do asset protection planning for our kids within a revocable trust. And the reason is, at the time my child inherits the property, this revocable trust has turned into an irrevocable trust because I have passed away. So step one with asset protection, if we're going to use a trust, it has to be an irrevocable trust. But please hear me, I'm saying step one, because I could still put together a trust for you, and that would be an irrevocable trust, and it still would have no asset protection. The first requirement of it is that it has to be an irrevocable trust. But there are other requirements that would be required to make sure this trust becomes a trust that we could use for asset protection. We could use for estate tax planning. I think I got probably about 6 more minutes. So with asset protection, there's really two main concepts. You set up LLCs sometimes we set up an entity, and that's used for asset protection. And then sometimes we use trusts, irrevocable trusts. The biggest difference is that if you set up an irrevocable trust, the main goal is 30,000 foot view. What we're trying to do is that we're trying to transfer asset into the trust, and then we're saying we don't own the property anymore. My example, I was saying if somebody sues me, they cannot take your property because I don't own it. That's the same thing. If I transfer my property into an asset protection irrevocable trust, if somebody sues me, I don't own it anymore. It's not part of my asset, so it makes it more difficult for them to attach. Let me take question after, since I only have a few minutes, but I will be here and my booth is right there. The other concept is that we do LLCs. With LLCs, we're not saying we don't own it anymore. If I have an apartment building, it's worth $10 million, If it's under my name, I own the apartment building. If I transfer it into an LLC, I don't own the apartment building anymore. The LLC owns the apartment building. I own the membership interest of the LLC. So now if somebody wants to come after my membership interest, there's a whole different set of laws that would determine how they could come after it. It makes it much more difficult. So the idea with LLC is not that I don't own it, is that maybe it's not as attractive to a creditor. They have to work much harder to attach my assets. They may have to wait a long time to get paid. So the idea is that it's going to make them maybe they don't want to come after this particular asset. It maybe give me leverage to negotiate with them. I could maybe settle for less. But those are the two main concepts. I really can't go into too much detail, but in the book that I have here, I have chapter 3 that discusses this asset protection planning using LLCs, using holding LLCs, using irrevocable trust. And then in the last few minutes I have, with these LLCs, or even any trust, I think I was at a seminar not too long ago, and whoever that was presenting, they were saying they're going to do some tax planning and then they'll do a free LLC for you. Run away from any offers like that. When we do asset protection planning, I may tell you may need an LLC, I may tell you may need a trust, but please don't be fooled by those titles. You could have an LLC and have absolutely no asset protection. You could have an irrevocable trust and still have no asset protection. It's really the content of the document that gives the asset protection. So we really want to make sure we have a comprehensive plan that addresses all those things. I know most clients don't actually read the operating agreement for their LLCs, but if there is ever a lawsuit, the opposing counsel is going to read every page and they're going to try to poke a hole at it. So you don't want somebody that is going to offer you a free LLC to do an LLC for you. That's not going to really do you a whole lot of good. So this is an example of some of the plannings that you could do. We could do a holding LLC. We use Wyoming a lot. You could have land trusts. You could have LLCs. You could connect it to an irrevocable trust. You could connect it into a revocable trust. This is sort of a general view of some of the planning that could be done. The other reason that we use trust, particularly irrevocable trust, is to do some estate tax planning. The exemption for this year is $13,610,000. That means that if somebody passes away in 2024, and let's say they have $14,610,000, that $1 million that was above the 13.6, 40% of that would be taxable for estate taxes. This exemption is going away beginning of 2026, so just about 8 months from now. I'm sorry, a year and 8 months from now. And one of the goals, it's going to be about half. So in 2026, the exemption most likely, instead of being $13,600,000, will probably be about $7 million. And so if you have a larger estate, what you want to do is you want to do some estate tax planning before the exemption goes away. And then how we do the exemption, how we do estate tax planning, that is done through some of the more advanced estate tax trusts. Again, these kind of trusts are usually irrevocable trusts, but just like I said, the fact that it's irrevocable, that's not going to be enough. It has to have other provisions in there so that we could use the trust to truly provide us with estate tax planning. Again, in the book that I have in chapter 4, I'll go through more detail as far as all the planning. I have a list here. Let me see if I could find this list since you guys want to take some pictures. This thing here, so these are some of the trusts: intentionally defective grantor's trust, a spousal lifetime access trust, qualified personal residence trust, all these different names that are used for different reasons for estate tax planning. And with estate tax planning, one thing you want to keep in mind, estate taxes are not due today. Estate taxes become due at the time the person passes away. So if, for example, somebody, let's say a couple has a $10 million estate and they're 50 years old, if they pass away, they won't have, if they pass away, let's say in 2024, they won't have any estate taxes, but the likelihood of them staying alive, it's going to be much longer. IRS says if you're 50, you have a more than 50% chance that you'll be alive until you're 86. So now if I have a $10 million estate, and if it doubles 4 or 5%, that means it doubles every 14 years. So by the time I'm 64, the 10 million is now $20 million. And then by the time I'm 64 plus 10, by the time I'm 78, it's now a $40 million estate. So you could see how this thing could compound, and now it's much easier and better to do estate tax planning at a younger age versus us trying to do estate tax planning at the time, let's say the client is 80 years old or 85 years old. It's much harder to avoid paying estate taxes. The goal is try to do something that we could completely avoid paying any estate taxes. But the second plan would be to at least reduce the estate taxes that could be paid. The book I wrote, initially it was like 250, 60 pages, and the publisher I have, he said, no, this is way too long, nobody's going to read this thing. So then I reduced it, now it's 75 pages. It's really intended that would be more of a overview of some of the techniques that can be used if we're talking about avoiding probate, if we're talking about avoiding estate taxes, if we want to do asset protection planning. They're all in here plus much more. So if you're looking to get more information about estate planning in general, I suggest getting a copy of it. And with that, I want to thank you for giving me 20 minutes of your time. I will be here if you have any questions. I'll be more than happy to speak with you. Thank you.